Mr. Pargaman is a partner in the Austin law firm of Saunders, Norval, Pargaman, and Atkins. Mr. Pargaman received his law degree from the University of Texas School of Law. He is certified as a specialist in estate planning and probate law by the Texas Board of Legal Specialization and is an ACTEC Fellow. He is very active in the real estate, probate, and trust law section of the State Bar of Texas. Today, Mr. Pargaman's presentation is titled Out with the Old Probate Code and In with the New Estates Code, 2013 Texas Estate and Trust Legislative Update. Please join me in welcoming to the stage Mr. William D. Pargaman.
Well, I've rearranged my speech just this week. I didn't really concentrate on the Estates Code very much until recently. I really focused more on the other legislative changes that were made last year because in my mind, the Estates Code really isn't that big of a change. It's just a matter of a new name for the code and new numbers for the statutes, but the statutes are essentially the same as they were before. It's just harder for us to find them. But I've now refocused more of the paper on the Estates Code because just by coincidence in January, I started getting emails from people all across the state with questions about the Estates Code. And I thought, well, you know, half of it was passed in 2009 and the other half was passed in 2011. Why are they just emailing me now? And it took me several days before the obvious answer occurred to me. None of those people bothered to look at the Estates Code until they had to. So because of that, there's some miscellaneous changes that were made last session on guardianships, detention orders, heirship changes. And I've found as I go through this paper, I often have to skip those things. So I've just taken them out of the PowerPoint. And therefore, I would recommend, for those of you who are practitioners, read the paper. You don't have to read all 170 some odd pages of it. Just the 15 pages in the main body of the paper, that's it. Because there may be a change in there that wasn't important to me, but it may be very important to you based on a case you may be handling right now. So what's new? The Estates Code is new. We're still going to be referring to our probate code sections, those of us who have practiced for a while, because we're going to resist having to learn the new section numbers. And I will tell you, I've noticed in many cases where we used to refer to a section, we will now refer to an entire chapter, because Leg Counsel has taken a lot of the things we had in one section and breaking them up into a number of sections which are in a chapter or a subchapter. For example, what we used to send out as a 128A notice, I now refer to as a Chapter 308 notice. To be specific, it's a Chapter 308 Subchapter A notice, but I usually leave out the A. Okay, the probate code was repealed after 58 years to the day. It was passed in 1955. It went into effect January 1st of 1956, and I hope my math is still good enough to subtract that well. It's not the biggest substantive change that's been made in the last few years, but it's the most noticeable because everything's rearranged. For those of us, if you're a new practitioner, you're in good shape because you'll just learn the new one from the beginning. But for those of us who practiced long enough that we're used to the old code sections and we're used to knowing where in our book to flip to real quickly to find it, it's going to be a while. You're going to be looking in the table of contents, or more likely, Professor Byers' disposition and derivation tables. I printed those out. I have them in a loose leaf notebook on my desktop right next to my probate code, which isn't a probate code anymore. It's an estates code. Okay, why do we have a new probate code, which is now called the Estates Code? It's not because anybody recently decided to do this. The decision was made over 50 years ago. Prior to 1963, all of our statutes were in this black statute thing called the revised statutes. Those statutes had been revised 4 times in the state's history, And what it means when they're revised is not that they change anything, but there's all these session laws that are passed, and somebody has to go through eventually and figure out, okay, when this was passed, did it add a new statute? Did it amend an existing one? And just to kind of clean them up periodically, the legislature would replace all the existing statutes with a new set with a new numbering format. And when they were passed, the revised statutes were passed in 1925, they started at Article 1, and they went up to Article 8,000 and something. By the way, most of the stuff I'm telling you on the Estates Code is in Attachment 2 to the paper. I actually drafted that as a separate article that you can download on my website, but I've copied the text of that article and put it in this paper. So, revised statutes went from 0 to 8429, say, something like that. There were no gaps in between. They were roughly alphabetical, and so if a brand new statute was passed, the publisher had to figure out where to fit it. And so they would start saying like 7525A, 7525B. And sometimes they were entirely new subjects and they had to stick a new title in there. And they just got confusing. And all the statutes on a particular subject weren't necessarily next to each other. It might be that one subject related to probate laws was in one place and another was in another place. That got very frustrating for probate practitioners, and beginning in the mid-40s, they decided they wanted to codify the probate statutes. This was not a government program. This was just a group of practitioners around the state. And finally, in 1955, they passed this probate code. It may have been one of the first in the nation passed in that format. And I believe it's in your paper. I think they drew statutes from 11 different volumes of the Vernon's Revised Civil Statutes. And they also pulled in some provisions from some uniform acts, came up with this probate code. The publisher had to decide where to put it, not the legislature. The publisher decides where to put it. And they stuck it in volumes 17A, B, and C because alphabetically probate fit between volume 17 and volume 18. That's where it was for many years. Well, that was passed in 55, went into effect in 56, but by 63, the legislature decided, we need a better idea. We need something that, so that all of our statutes are consistently numbered so it's easier to find things. They're organized better. They're grouped more by subject matter. And we get rid of duplicative things that conflict with each other, and archaic language. So they passed a statute telling to the Texas Legislative Council, which is kind of the law firm of the legislature, to study this and come back with a report. And by 1965, the Legislative Council reported back, and they said, this is what we think you should do. We think there should be 26 different codes, and we think you should have us do the work. And so that's what they did. Eventually, they added one other code. At the time they started this in the early 60s, Ledge Council predicted it would take them 10 to 15 years to complete the whole codification process. They don't have the manpower to recodify every single statute in just 1-2 year biennium. Well, it took them a little longer than 10 to 15 years because they started in the 60s and they didn't get around to even looking at the probate code until 2006, 40 years later. And they purposefully put the probate code off to last. One of the reasons was because the people in the real estate probate and trust law section said, hey, we've got a working probate code. Leave it alone as long as you can. And they recognized this and realized, okay, while it's not organized as well as we would do under the statutory revision program, at least because of what was done in 1955, it's organized better than many of the statutes, so we can put that off to the last. But they finally started working on the probate code in 2006. The purpose of the whole statutory revision program reclassify, rearrange statutes, have a more consistent and organized numbering system that accommodates future expansion. That's why you'll see a lot of gaps in the numbering of the probate code. Eliminate repealed, invalid, duplicative, and ineffective provisions, and improve drafting. But an interesting thing about it is if they think an existing statute is ambiguous, their job is to draft a new statute that is equally ambiguous. It's supposed to be non-substantive, and if the substantive law isn't clear, they aren't allowed in their drafting process to clarify it, because that's making a substantive decision as to how it should be interpreted. Now, after they prepared all their non-substantive provisions, we're now looking at all the ones they prepared these reviser's notes, which have their comments on each section, where it came from, and if something was ambiguous, they explained what they thought the ambiguity is and how they preserved it. And so we were able to download those reviser's notes electronically and search for the word ambiguous or ambiguity, and every time it came up, we'd look at that and decide, well, do we want to clarify that? Because REPTL, Real Estate Probate and Trust Law section, can and does propose substantive changes. And so we'll probably clarify a couple of those ambiguities in 2015. As I said, the probate code wasn't a code for purposes of the statutory revision program. It wasn't drafted under the Legislative Council supervision. It didn't have the same kind of numbering system. For those of us who've ever tried to find something without an adequate index, it's not particularly well organized. And so we always knew that it was going to be recodified. 2006 is when they started doing it. It was really too big for Legislative Council to do it all in one session. And there were certain provisions, primarily some clarification of independent administration statutes and jurisdiction and venue, that they said, you know, we really don't want to touch those. They're complicated as they are, and in order for us to redraft them in a non-substantive way where we don't eliminate ambiguities would be very difficult. So they left that up to the Real Estate Probate and Trust Law section, and we drafted substantive legislation to accompany the non-substantive provisions that Legislative Council drafted. The decedent's estates provisions were passed in 2009. Guardianship and power of attorney provisions in 2011. There was some general code updates when, for example, somebody in the meantime would make a change to the probate code. When the estates code went into effect, it was supposed to be a non-substantive reflection of the existing law on the day immediately before when it went into effect. So then Leg Council would have to have these separate bills revising the estates code provisions that had already been passed to conform to whatever substantive changes were recently made in the probate code. Why is it all effective January 1st? Well, Leg Council's idea was we want everything to go into effect during the following session. So, for example, when they were going to pass the decedent's estates provisions in 2009, they wanted to wait until 2011 for it to be effective, and in fact, they picked originally April 1st or April 30th, I think April 1st of 2011 as an effective date, thinking that if there's anything we need to correct, the legislature can make those technical corrections at the beginning of that section, that next session, and have it go into effect right after. The changes would be made before it became effective. Then they were going to have the guardianship and power of attorney provisions effective in 2013. REPTL didn't really care for that. They said, look, let's just have it all be effective at the same time. We don't want to have a 2-year period where we're dealing with the probate code half the time and a different code the other half of the time. So we said, let's just make them all effective after the second version was passed. And most statutes that are passed are effective September 1st of the year in which they're passed. We suggested, this is such a big change, let's just do it on a calendar year basis. So we'll delay it until January 1st of the year after the 2013 session. That's how January 1st was picked. The name. Legislative Council researched the names of similar statutes in all the other states and probably some territories. They made a list of it. They provided it to us. I don't know that we decided. I think Legislative Council originally picked the name, except the name they picked was the Estates and Guardianship Code, one of the longer names for the codes that they have. It's certainly not as easy to say as the Property Code or the Family Code. And Will Hartnett, who used to be a legislator from the Dallas area, usually sponsored our bills. He was the sponsor of the non-substantive bill that Leg Council had proposed. And it went through the House committee. It was getting ready for a vote on the House floor, and he contacts me and he says, you know, that's just more than a mouthful. Can't we think of another name? And I actually sent him that list that Leg Council had prepared of all the names that they'd reviewed. And I said, but you can name it anything you want. My suggestion, it's going to sound like it's a joke, but it was for real. I suggested the new probate code. Leg Council didn't want to use the same name, but I thought, you know, everybody's going to call it the new probate code for a number of years. Let's just call it that. Apple's done it with their iPads. Coke did it years ago with their new formula. But he didn't go for that, so he just decided to shorten it to the Texas Estates Code. That's why it has that name. One little bit of trivia also, the Estates Code does not start with Chapter 1. It starts with Chapter 21. And it wasn't until fairly recently that I found out why. Some people asked me the question. I never thought to ask it, so I contacted the people at Leg Council. And the little story behind why it started at Chapter 21 is in there. And the reason why has now gone away. And so I suggested to the people at Reptil that if we wanted to next session, we could renumber those beginning statutes starting with Chapter 1, but nobody seemed to want to mess with it. So I think you're safe in relying on the new code section numbers. Okay, free resources. These revisers reports. There's two of them. They're each about 400 pages long. You can download them for free. This is what Legislative Council passed after each of the non-substantive provisions was drafted, and it talks about where the statutes came from, how they were drafted, any changes they made, and if there were ambiguities that they were trying to preserve, they explain those. You may not care about all that. And so if you don't, just download Professor Byers' disposition and derivation tables from his website. It's about, 40 or some odd pages, and the first half is by probate code section, which is the part I use the most. I'm trying to figure out where did my dear old Section 59 or Section 128 or 145 go. It'll tell you where to find it in the Estates Code. He's also got derivation tables following it, so if you're in the Estates Code and want to figure out where it came from, it's easy to find the probate code statute that way. And so these are all pretty handy. For the most part, that's all you're going to need. You don't really need 800 pages to tell you where to find the statutes you're looking for. The official States Code is online. It's actually been online since 2011 with all the other Texas codes. The last time I checked was earlier this week. None of those statutes had yet been revised for the 2013 changes. They all still reflect the 2011 version of the statutes. When I first started doing this in the late 2000s, they usually had it revised by the fall of the year in which the session occurred, which would have been last fall. Then they started doing it early the next year, like in January or February. We're now into March. I'm not sure why it's taking them longer. My understanding is the work is actually done by West Publishing Company because they publish the official session laws. And so if there's a delay, it's probably a delay on West's part. Practical questions. You had a pending estate administration on December 31st. Do you now follow the probate code or estates code? You follow the estates code. The probate code has been repealed. Now, if there was a substantive change made last session, you have to look at the transition provision effective or applicable for that change, and whether it applies to pending estates on January 1st or whether it applies to only decedents dying on or after a particular date, that sort of thing. And in some of those situations, even though a probate code statute's been repealed, it may say for persons dying before January 1st, the law that existed at that time will continue to apply even though officially it's been repealed. Next, do you have to replete all your forms where you have references to the probate code? I would not suggest that. I haven't talked with the judge who requires it, but anything you prepare in that case following January 1st should, to the extent it had references to statutes, reflect the new statute number. That would include if you file an amended pleading, if you file one of those 128A notices, which is now a Chapter 308 notice, and if you're preparing an order for a judge to sign that reflects it. I don't really have that many statutory references in my forms because it's really not necessary. It's not because I was really smart and knew that it would cause problems. It's just, I just don't have that many. Now, that's in your pleadings. What about in your wills? I want a show of hands. How many of you still see relatively recent documents that refer to the Texas Trust Act? Well, of course you would. That's Charles King, one of your featured speakers. I still see it a lot. The Texas Trust Act was replaced by the Texas Trust Code over 30 years ago. Actually, it was 30 years ago on January 1st. Now, the Texas Trust Code has a provision at the beginning because it was not completely non-substantive. The Real Estate Probate and Trust Law section took the opportunity of the enactment of the Property Code to make some substantive changes to our trust laws. And it has a provision at the very beginning that says if there's a reference in any document to the Texas Trust Act, then it should be considered now a reference to the corresponding provision of the Texas Trust Code. So you had a statutory savings clause. The Estates Code has one of those, but it only refers to references to the Probate Code in other statutes. And part of Ledge Counsel's job is to find those statutes and get them amended in one of these general code update bills. It doesn't say anything about references to the Probate Code in wills or trust documents. Those are probably, however, okay because of the fact that with respect to both wills and trusts, the cardinal rule is that the intent of the testator or settlor governs. And by referring to a provision in the Probate Code, it's pretty clear what the testator's intent was, so you would think that a court would interpret it by looking at the corresponding Estates Code provision. But even if that's the case, it's going to make you look unprofessional if somebody sees those Probate Code references, so I'd change them. There's not supposed to be any substantive changes in the Estates Code, but there's a discussion in the paper about the Fleming Foods line of decisions where the Supreme Court said, yeah, even if your intent was not to make a substantive change, if the language that was used actually does make a substantive change and it's clear and unambiguous, you can't argue that a court should interpret it in accordance with the old version. You have to apply the statute as written. Okay, Reptil. We're going to go through this fairly quickly. We had three main bills. We usually have three main bills: decedents, estates, guardianships, and trusts. There's a constitutional provision here in Texas that requires that every bill other than a budget bill has to be limited to one subject. And there were several things in our bills that really didn't apply to, say, decedents, estates, or guardianships or trusts. So Ledge Counsel took all those things out and put them in what I call our small bills: medical, powers of attorney, exempt property, and a title insurance bill. I'm not going to talk about it because the Texas Land Title Association had problems with it, so we dropped it fairly soon. And then there's also the general code update bills, which were not our bills, but we were very interested in getting them passed because they had very important cleanups. The decedents' estates. Well, the Reptil bills, let me just mention this. When they're introduced, they have the provisions that we propose that were approved by the State Bar Board of Directors. A replicant can't propose things on its own. You have to go through this approval process to make sure other sections don't have valid objections. Once it's introduced, it's no longer Reptil's bill. I'll call it that while it's going through, but any legislature is free to try to tack on an amendment. Sometimes they get consolidated by agreement with other bills on similar subjects. That doesn't mean everything in the Reptil bill by the time it passes was a Reptil proposal. I try in the paper to point out when things were added to Reptil bills that were not originally Reptil proposals, because that way if you don't like it, you won't blame us. It just happens. On affidavits in lieu of inventory, some judges, this became available in 2011, and some judges took the position that you couldn't use it if your will directed that an inventory be filed, and most wills do, because the sentence that's most commonly used to provide for independent administration says, I direct that no action be had in any court of probate jurisdiction other than the probating of this will and the filing of an inventory and list of claims, or words very similar to that. Respectfully, I believe those judges were wrong, but nevertheless, we passed an amendment to clarify that the only way that you are required to file an affidavit is if the will expressly prohibits you, the only way you're required to file the inventory is if the will expressly prohibits you from filing an affidavit in lieu of inventory. The executor can't be held liable for making the choice between either filing an inventory or filing an affidavit in lieu. We don't want to put them in a position where they don't know which is going to keep the beneficiaries happy. I'd suggest you revise your will forms, that language that you've probably got in your forms that I just recited. I'd make a reference to any required inventory, or refer to an inventory or an affidavit in lieu of inventory. There's a lot of miscellaneous changes on airships. I won't mention them, all of them. The most significant one to me is the applicant's required to provide notice to a number of people listed in the statute. Now the applicant is going to be required to file with the court either an affidavit of the applicant that they gave all the required notices, or the attorney can file a certificate saying that all the notices have been provided. If you don't file either that affidavit or the notice, the court is prohibited from signing a final judgment determining the heirs until that gets done. Addresses and applications for letters. You name your executor. Previously, you named the residence, which is usually the home address of the executor. Some people don't like their home address in public documents. So now you have to list the state of residence of the executor to know whether you have to have a designation of resident agent, and you have to have some physical address where the executor can be served. Some people may choose to use a work address. Previously, you were supposed to list the names of the witnesses to the will and their addresses. Most often we would put, we don't know what their current address is. You don't have to make any reference to their addresses anymore. You just state their names, and that you should be able to get from the will. The probate judges wanted and received a statute allowing them to impose a $1,000 fine if you fail to file an inventory timely, meaning you didn't get extensions, and they've given you all sorts of notice, and you had a hearing and you still didn't file one, then they can impose a fine. And if you don't file an inventory after all of that kind of notice, you probably deserve to be fined. Finally, up until this year, when a successor representative was appointed, they had to file an inventory, and it was supposed to list all the assets on date of death, even if all those assets or most of them had been distributed. Now, the new rule is if a previous executor has already filed a date of death inventory, then when the successor is appointed, they just list the assets and their value that were still on hand on the date of their qualification. So it should be, in many cases, a much, much shorter inventory. When you file a final account in a dependent administration, you now have to actually provide a copy, not just a notice, to all the beneficiaries of the estate, but you can deliver it electronically by email if you want. Creditors' claims in independent administrations, if they're not presented by actually filing suit, you now have to go back to using an authenticated claim that you present. Previously, it didn't say what kind of written instrument the creditor had to provide the executor. The probate judges got enacted kind of a tiered system for notices. There's various grounds for removing an independent executor, and so they've listed the various grounds but said, okay, for these really bad things, you can remove them without notice. For these, you can remove them, but you got to give them 30 days notice by certified mail. And then for these other ones, you have to provide personal service if you're going to remove them. So anytime you have a removal action, you need to look and see what kind of notice is required. A couple of bills that were not reputable bills. A bill that was well intended said you can't disclaim property in order to avoid paying a child support obligation that you have. Of course, it seems to me in many cases that disclaimed property might end up going to the child you're supposed to be supporting. But apparently there was a concern some people were using it inappropriately this way. The law has been changed. You can't do it. Child support obligation doesn't mean any child support obligation. It means you've been judicially determined or administratively determined to be in arrears in some obligation. And in that case, you can't use a disclaimer to avoid it. Most importantly for practitioners is, in order to be effective, every disclaimer has to have a statement in it, whether or not the disclaimant is a child support obligor. The statute says in order to be effective, it has to have that statement. So if you accidentally leave it off because the person who's disclaiming never even had kids, so you don't think it's relevant, the statute literally says it's not effective, in which case it's not going to be effective for federal purposes. We're going to try to clean that up in the next session so that while the disclaimer would still be ineffective as to child support obligations, failure to include the statement won't invalidate it. Texans for Lawsuit Reform, which is behind all the tort reform, decided to look at the probate code, and in 2009 we passed a statutory provision on what are the grounds for avoiding enforcement of a no contest provision in the will. They had it revised. Their first provisions were pretty horrible. We pretty much weakened the changes to the point where I don't think it makes much of a change to the statute, but that change was made both to the estates code and a similar provision in the trust code. Guardianships. The applicant is now going to be responsible for paying the initial filing fee, including the ad litem deposit. This means they pay it. They can't file an affidavit of indigency saying the ward has no assets. The ward's estate doesn't matter. It's the applicant. If they've got assets, they got to pay the fee. Now, if the ward does have assets in their estate, the applicant can seek reimbursement after the estate is created. But otherwise, the intent of the statute was that if the applicant can afford it, the county treasury is not going to have to pay it. It was not drafted well. It may need correcting because it's not clear whether the county reimburses part of it now. But that's the way it's drafted. It wasn't the way we suggested it. Attorney's fees and costs can be assessed against a party to the guardianship if they're what we refer to as a bad actor or a black sheep member of the family keeps filing these frivolous things. Right now, or before this year, most of those costs were paid out of the ward's estate regardless. Now the court can assess them against a party. The information letters that people can send to the judge saying, you know, I don't know for sure, but we think you ought to have somebody check our next door neighbor. We think she may need a guardian. Now you have to state that it's the facts that you allege in the information letter are to the best of your knowledge. And if you happen to be a relative of this person you're asking the court to investigate, you have to either swear to it or use one of those unsworn declarations that were enacted in 2011. Medical power of attorney bill, very minor cleanup. In 2009, the statutes were revised for most of those health care directives to allow you to use one notary instead of two witnesses. But the actual statutory health care power of attorney form did not have a notary blank. It still just had two witnesses, and the disclosure statement that the principals are required to read still said this has to have two witnesses. So all that happened on that this year was the form itself and the disclosure statement were revised to acknowledge the fact that using one notary is perfectly acceptable. Non-reptile financial power of attorney form. I emphasize non-reptile. Reptile did not want to change the statutory form. It was changed over our objections. Primarily, this was an initiative of the AARP. They felt that there would be less abuse of powers of attorney if the principal was required to initial the powers that they're granting, because that made them think about it before they granted them, because our current statutory form that we've had since '97 lists all the powers, grants them by default, and you cross them out if you don't want to grant them. We didn't really think that that was going to make them that much better, because if somebody's going to sign the thing without paying attention to it, they'll initial the thing without paying attention to it. Plus, what if they sign it but they don't initial anything, and it was clear they intended to give a power of attorney to somebody, but they didn't give them any powers? But nevertheless, it passed. My point that I emphasize in the paper, though, is this is a voluntary form. It's not a mandatory form. I've used what I call a statutory form pretty much since it was enacted, but since it was enacted, I've already had changes where I customize the form that I use for my clients. This is no different. I chose to add some new notices to both the principal and agent, because I think those were good additions that are in the new form, but I didn't change my strikeout method to the initialing method. You can do whatever you prefer when you're preparing your own powers of attorney. Glenn Carish has posted the new forms on his website. He has one straight out of the statute. He also has a version that has some of his customization, so you can get an idea how he changes them. The trust bill. This was passed under the stewardship of our previous speaker. It had various provisions in it. I'm just going to mention a few. At the end of 2012, when we didn't know what the 2013 estate tax laws were going to be, we had a whole bunch of people creating trusts. Often they would create them for their spouses, and they'd give the spouse a broad power of appointment. The spouse then dies. They have a provision in their will exercising their power to appoint it back to a trust for the original settlor. Under common law rules applicable to powers of appointment, even though the original settlor had nothing to do with the later creation of a trust for their benefit, they're still considered a settlor of that trust for creditor purposes, and therefore you lose the creditor protection, which also means it's included in the settlor's estate. We've changed that in most situations. It may still be considered to have lost its spendthrift protection, but the mere fact that the assets came from a trust that that person originally created, that fact alone won't be enough to lose the spendthrift protection. Two tax code changes. The main one I'm going to mention is if you've got a homestead in a trust, it's easier to have the qualifying language, if it wasn't already in the trust, to qualify for the property tax exemption. And it's no longer limited to the original owner and the owner's spouse. You can have a lifetime trust for a child that can now benefit from that property tax exemption for homesteads. Decanting, I'm not going to talk about decanting, kind of for obvious reasons. You've already heard a much better presentation on it. There was a slight change in the venue provisions where there are multiple individual trustees. It was written by us to only apply where there were multiple individuals and no corporate trustee. But the way Ledge Counsel wrote it, it applies where there are multiple individual trustees, whether or not there's a corporate trustee. And then there's another venue provision that applies if you have a corporate trustee, so they overlap. Hopefully in 2015 we'll fix it. There's a provision in our Decedent's Estates Bill. This has to do with joint accounts with right of survivorship. It's meant to overrule a Texas Appeals Court decision. And essentially it says, if your account agreement provides for right of survivorship, but it doesn't do so in a way that's valid under Texas law, however, the account agreement says it's governed by the laws of some other state, and it may have been valid under the laws of that state. If more than 50% of the assets in the account were contributed by Texas residents, then we're going to say Texas law applies to the validity. Now, it doesn't affect the liability of the bank if they pay out pursuant to the survivorship provision to the survivor on the account, but it wasn't valid under Texas law. They aren't held liable, but it allows the executor in those situations to go back and try to recover the funds from the survivorship party or the quasi-survivorship party. We're getting near the end. There's some changes. There were changes last session, increasing allowances and homestead protection for adult incapacitated children. We realized that might cause problems if they were qualified for governmental benefits. The existence of this allowance could disqualify them, so it's been taken away if they weren't already being supported by the decedent. Some other changes relating to insurance beneficiaries naming the estate and clarification that Roth IRAs are protected. The allowances in lieu of homestead and exempt property went up from an aggregate amount of $20,000 to $75,000. We're almost done. The expedited action rules that the Supreme Court's directed to adopt, and they've already adopted some, when they enacted the law requiring that those rules be adopted, they exempted actions under the Family Code and actions under the Property Code, which meant trust code proceedings were exempt. Didn't mention probate code or estates code. Now we've added something not to the Civil Practice and Remedies Code where that original statute was, but to the estates code itself that says those rules aren't going to apply to actions under the estates code. If you're doing depositions on written questions and it's a complicated procedure, many county courts don't know how to do it, where they're supposed to issue a commission after the notice has been posted for 10 days. They don't have to issue the commission anymore. It should be much simpler. You can always download the latest version. I think I have a slightly different version than what you've got on my website. It's not different enough to make it worthwhile. As people ask me questions and I answer them and I think, oh, I ought to put that in the paper, I'm still revising it. So you might check back in a month or so. I'm probably going to revise that attachment about the estates code. But if you don't want to print out the whole thing, you can either print just that attachment or I'll have it posted separately as a standalone paper. And I'm done.
Turn out the lights. The party's over.
We're done with that.